Hello, today we will be talking about labor laws in Brazil, more specifically, how the sources of labor law are organized and how do labor courts and tribunals operate in Brazil. In Brazil, there exist multiple sources from which labor laws can be found. These domestic sources are the rules and the laws that dictate employer relationships in Brazil and can be found in the 1988 Constitution as well as in the Consolidated Labor Laws or the Labor Code. And there does also exist ancillary legislation when it comes to labor relations. The 1988 Constitution of Brazil discusses a variety of labor law provisions. The Constitution was an advance in political and democratic agreements and thus helped to develop a lot of what was previously missing in the Constitution of Brazil. So, in regards to labor laws, there are provisions that legalize unions as well as collective bargaining and the right to strike in both public and private sectors. In addition, the Constitution also sets overtime rates, monthly minimum wage, and it regulates working hours, as well as listing a variety of labor entitlements, including maternity leave and vacation, workers' compensation, social services, as well as medical assistance and other unemployment benefits. As I mentioned, the Constitution does allow for the creation of unions. In Brazil, there is labor management relations in which a single union represents all of the workers of a specific industrial sector in a specific geographical location. The Constitution also allows a lot of freedom when it comes to striking and workers going on strike, but there are limitations which are set partly by the Constitution and by other labor codes. These limits include mandating warning period, for example, as well as the protection of essential services such as utilities and public transport. And in addition, there needs to be a minimum number of votes that need to be handed in order for this strike to actually be able to go through. However, of course, it is always recommended that companies hold discussions and negotiations with labor representatives before the strike actually happens. The Consolidated Labor Laws has been amended as recently as 2019. It is the principal statute that regulates employment and labor relations in Brazil. The Labor Code has modernized the legal framework by giving more power to employers and employees to negotiate the terms and conditions of employment, but also preserving the minimum labor and employment standards that are noted in the Constitution. It has reduced interface of labor courts in the law and collective negotiations, and it has created new forms of hiring and termination. In addition, changes that have come out because of the labor code are in regards to releases and waivers, new termination forms, new employment contracts, flexible working times, reviews of compensation payments and other rights, as well as the possibility to outsource, and the review of individual and collective bargaining and union proceedings.
Now we're going to discuss the role of the labor courts in dealing with claims. Labor courts in Brazil are divided into three main tiers. The first instance of the claim is dealt with by the trial courts, and there's almost 1,600 of these courts. Following that is the common appeal level, which is held in the regional labor courts. There are 24 of these for the different regions in Brazil. And finally is the highest appellate level, which is a superior level court. At the appellate and the superior levels, the labor courts will issue case law in the form of consolidated precedents. The labor courts, which are independent and specialized, have the authority and the jurisdiction to hear complaints. The judicial process occurs in the first-degree courts, and it begins when an application is assigned to the judge. At the first stage, there's a requirement of an attempt of conciliation. If this is not successful, then the judge will decide the case. Following this, in the regional court, in the second degree, the judge can decide on new cases, or it can receive appeals against decisions that were made in the first degree or in the trial court. The appeals are reviewed by a panel of judges, and if these rulings are appealed further, then this occurs in the Superior Labor Court, which is the highest level. In order to submit a claim, there are several steps that need to be taken in the following procedure. The complaint and the defense both need to be written in order for the first hearing to occur. After the first hearing is the judgment, and then the opportunity to appeal the rulings that were made. Following the appeal, there's the enforcement. Typically, the timescale for claims are 2 to 3 years, which of course changes depending on the opportunities of special appeals and how many times it is appealed. The case will of course last longer. The trial court decisions are appealable also in the regional courts as well as the first trial court.
Now we'll be talking about alternative dispute resolutions. Currently, there's two main forms of ADR in place, which are most commonly used, and these are arbitration and mediation. Some important things to note, first of all, is the Civil Procedure Code, which entered in 2015 and fosters mediation and settlements as ways to resolve conflict. It provided measures to encourage parties to adopt ADR methods. Also, the Labor Reform of 2017, which was quite controversial and radical, but among many other things, encouraged ADR methods to resolve disputes. And also, finally, the Mediation Act, which regulates mediation, which also was enacted in 2015. So before the 2017 labor reform, arbitration clauses in contracts were not used commonly, were not really used. An arbitration clause requires parties to resolve their disputes through an arbitration process, and they're inserted in contracts between employers and employees. And after the reform in 2017, parties were now able to incorporate arbitration clauses in the contracts with the requirement, the exception that this should be done for employees that whose remuneration is higher than 12,000 Brazilian reals. And the reason for this being that these employees will have access to more resources and have the ability to acquire better ADR services. And this marked the first time that ADR was accepted as a legitimate tool by Brazilian authorities to resolve disputes, and by doing that, giving employees and employers an ability to avoid litigation between parties. However, there's still some distrust from Brazilian courts, and according to the CPC and their panel, one of the CPC Institute, the first reason for this is that labor law was not seen, or in the traditional sense, is not seen as being capable of arbitration by nature. Also, there's a general misuse of arbitration where employees use unreliable arbitration chambers. And finally, courts see themselves as the guardians of labor rights and delegating them to private entities would threaten their protections. However, regardless of this, ADR is growing in Brazil due to promoting in the inclusion of arbitration clauses by companies. And this is being done because of the benefits that they have, which is, for one, being able to keep it confidential, and also how it's quick and efficient in resolving the labor disputes. Also, in the past couple of years, more mediation chambers have been created to meet the demand for this tool. For example, Banco do Brasil has implemented a program to resolve complaints such as sexual harassment or moral harassment to employees, which has had success, according to the CPC Institute. The active participation of unions in moderation has given the court system confidence and is essential for the success of the tool. And this is important because mediation agreements are not shielded by the principle of finality unless approved by the courts, unlike other legal systems. And the most effective situation where mediation is employed is when courts push parties to settle themselves, especially when there's small claims. Finally, these are the main bodies and institutions for alternative dispute resolution in Brazil. Firstly, the International Court of Arbitration of the International Chamber of Commerce, the ICC. Then the Chamber of Commerce for Brazil, Canada. The Arbitration Center for the American Chamber in Sao Paulo. The Chamber of Mediation and Arbitration of Sao Paulo. And the Chamber of Conciliation and Arbitration, FGV. Thank you very much.